Fast forward with our tech. Okay, anyhow, just want to again emphasize that our federal people who are here, they're big dogs, and we're really lucky to have them here. Okay, they're big dogs, they're enforcers, they're investigators, they take complaints, but today, they're puppy dogs, okay? They are here to provide technical assistance and outreach. Look at them, they're puppy dogs. They're smiling, exactly. And they love coming to Hawaii and they want to help. They really, truly want to help. So I know some of you out there are like, oh, we're so not up to speed with our language access plan, or like, don't bury your head in the sand and just hope you don't get investigated. Now is your opportunity to ask questions and to, get it straight from the big dog's mouth, the puppy dog's mouth.
Hello.
Right? Hello. Oh, hello. Can you hear us, Christine? I hear feedback. Uh-oh. Okay. You know what we're going to do? We're just going to go straight to Michael while we work on this. Will that be okay? Yeah? Okay. So let's bring up Michael, Leoz, and Danielle. Danielle Archuleta. Did I say that right? And Eric, you're going to stay? Okay. And then Stephanie Franklin. So Michael and Leoz and Danielle Archuleta, they're from the U.S. Federal Department of Health and Human Services, Region 9. So they look at Hawaii, California. Come on up. Whatever way you're comfortable. And Stephanie, you remember from yesterday. She's from the Office of Human Rights, and she's from their language access program, their Office of Language Access over in the DC area. So they're going to talk to us about federal enforcement investigation and some guidelines for how they monitor your compliance. And also looking at some of your sub-recipients, meaning if you have government funds that you're giving to a vendor, they are obligated as an extension of you, government agency, to provide language access as well. So without further ado, we'll just get started with Michael. I'll find your PowerPoint.
So good morning. Let's see. Can you hear me? Okay. So, well, thank you, Becky, for that introduction, and we're not really that scary. So, part of what we're here to do is actually, although we are an enforcement agency and we are required to, make sure that covered entities are in compliance with their obligations, we also, a big part of what we do is actually provide outreach and technical assistance to covered entities. Sort of think of it as preventive, like preventive health. So if you're doing, if you've got a language access plan, if you've got certain things in place, you're probably more likely than not going to be in compliance with your federal obligations. So I'm going to talk a little bit about, let's see, is the PowerPoint up?
So I have a pointer, or I can do it for you here. What do you prefer? It's over. To the right.
This one? Okay. So this first slide is sort of an outline of what we're going to cover. So, I'm going to give you a little bit of an overview about OCR, who we are, and just curious, how many of you actually know of our agency? Okay, good. So it's always interesting because we speak at conferences or go out and provide technical assistance, and there are a lot of agencies, individuals who don't really know about our agency and what we do. So I'll go through that a little bit. So our mission basically is to ensure that there is equal opportunity for services in the health and human services. We also enforce the HIPAA privacy and security rules, breach notification. Just curious, do any of you work with HIPAA? Yes. Okay. So that's a big part of what we do as well. So we have basically two main areas. But let me just go back. This is an org chart of HHS. So OCR, although we're the enforcement agency within Health and Human Services, we're actually a very small part of Health and Human Services. So many of you who do work with Health and Human Services probably work with Administration for Children and Families, CMS, Centers for Medicaid and Medicare Services, and many others, HRSA, for example. So we are part of Health and Human Services, and other federal agencies also do have an Office for Civil Rights, so Department of Education, Department of Labor. So depending on what type of agency you are, you probably will work with the Civil Rights Division within that part of government. So Danny and Eric, who's also here in the audience from our office, we're part of the Pacific region. And so if you look at the map, the Pacific OCR is split up into different areas, geographic areas. So the Pacific region covers 8 western states, including the state of Hawaii, and also the Pacific territories. So if there is a complaint that is filed in Hawaii or Pacific territories or any of the other states, that'll come to the Pacific region. So just so you know, actually California is sort of our big state within the Pacific region, so about half of our complaints come out of that state. And then Washington State is sort of number 2 in terms of complaints. Part of that is demographics, geography, but we do, we do get complaints that arise out of Hawaii, and we'll talk a little bit about that as well. But that's basically our geographic area. So if there's something that rises out of the state of Hawaii, that'll come to our region, the Pacific region. That next slide is basically our authorities. So you can see it's a lot. So we are responsible for enforcing a lot of federal civil rights laws. So that first column are the federal civil rights laws that we enforce. So it includes not only Title VI of the Civil Rights Act, and also Section 1557, which is what we're going to focus on today during today's discussion. But if you do work with, disability community, we also enforce Title II of the ADA, Section 504 of the Rehabilitation Act. If you work with persons who are deaf or hard of hearing, that also falls under our jurisdiction, and that falls under Section 504 of the Rehabilitation Act, having to provide effective communication. And then if you look at the other part, a big part of what we do also is we also enforce HIPAA. And within that, we enforce the privacy, security, and breach notification rules. So, for example, if you ever see anything in the news, for example, about a big breach of protected health information that occurs within a hospital setting, for example, that'll come to us if it falls in one of the states that are part of our geographic area. So, as I mentioned, we do have a lot of enforcement tools. A big part of it is preventing violations. So that part of that is why we're here. Giving you some best practices. And so you can also hear from, the panels yesterday I thought were really good about, some of the practices that have been put in place with some of, different providers and covered entities, as we would call them. So, networking and finding out what are other states doing, what are other jurisdictions, what are other hospitals or healthcare organizations in the state of Hawaii doing. We know that there are always limited resources, so I think that's a big part of a big value of a conference like this. Also talking with us. We are going to have a consultation session at 10:30 where we can go into sort of, you have very complex questions or very detailed questions, we can sort of answer those during the 10:30 session. So we also provide a lot of technical assistance. Our website actually does include a lot of information about our different laws, and we include tips on our website as well. What you can do. We have guidance documents. We have frequently asked questions. So we've redesigned the website. It's supposed to be more user friendly. So hopefully that's the case. But we welcome comments on that, and we'll talk about how you can get in contact with us. And then, of course, a big part of what we do is complaint investigations. So if we get a complaint, we do have to investigate it. We are required by our laws generally to try to voluntarily resolve those. So that could end up, we may ask that there be corrective action taken voluntarily. And we may also enter into a resolution agreement with a covered entity. And what the resolution agreement does, it basically requires a monitoring where we actually monitor the terms of the agreement. So we may ask for, additional training, staff training. We may ask for revised policies and procedures. So, and then within those resolution agreements, we do monitor those. And then on the HIPAA side, we actually can we can issue civil money penalties. And on the civil rights side, if there really is a really gross violation, we could terminate federal funding, although we hardly ever do that. So those are sort of our various enforcement tools. We have made it easy to file a complaint with our office. So there is an online complaint portal. So if anyone, for example, feels that they've been discriminated against because, let's say, they weren't provided with an interpreter or they weren't provided meaningful access, they can file a complaint with us. And again, as I said, it's a centralized system, and what will happen is if they determine that it's filed, for example, in the state of Hawaii, it'll come to our region. So it's very user-friendly. So the first law that I want to touch upon is Title VI of the Civil Rights Act of 1964, and I think you heard about it yesterday, so I think most of you in the room are familiar with Title VI. But basically, it's a long-standing statute basically saying that no person shall be discriminated against on the basis of race, color, or national origin. So how does language fit into this? So language access, national origin is covered under the national origin provision of Title VI. So there was a Supreme Court decision in 1974, Lau versus Nichols, that basically says that Title VI prohibits conduct that has a disproportionate effect on LEP persons because such conduct constitutes national origin discrimination. So again, it is a requirement under federal law under Title VI. Title VI applies to HHS federal fund recipients. So if you get funding from the U.S. Department of Health and Human Services, and I'll give some examples of that, you are basically required to comply with Title VI. So Danny's going to be talking about Section 1557, which is our brand new regulation, which is the non-discrimination of the Affordable Care Act. And there is some overlap between whether you have to comply with Title VI and 1557, but there are some differences. So some of you may have only to comply with Title VI, but some of you will have overlapping, so you have to comply with both Title VI and 1557, depending on what kind of entity you are, whether you receive federal funding from HHS. But for purposes of Title VI, if you receive any type of federal funding, you are required to comply with Title VI. So as you can see, that's a pretty extensive, common types of federal financial assistance. It includes grants, it includes lots of different types of assistance. So generally speaking, if you participate in Medicaid or Medicare programs, you are required to comply with Title VI. And then, there's common types of, common recipients would include hospitals, healthcare healthcare organizations, physicians who participate in the Medicaid or Medicare program. So it's a wide range of entities that fall under Title VI. The key concept for language access is meaningful access. So basically the general rule is that recipients must take reasonable steps to ensure meaningful access to their programs, activities, and services for LEP persons. So again, I know you heard that during yesterday's panels. And again, you heard about how some covered entities that have established good policies and procedures, how they were able, what steps they've been taking to provide meaningful access to the individuals that they encounter who are limited English proficient. We do have guidance on our website. It's the HHS LEP guidance. We have a link to it. And certainly, if you are required to comply with Title VI, the guidance is actually a really good guidance document that sort of gives a step-by-step, here are some steps that you can take to be in compliance with Title VI. So this basically, the next slide sort of gives some sort of examples of, if you have a language access plan, for example, that is a good starting point to ensure compliance with Title VI. So with respect, so I know you've heard a lot about Title VI, and I think you're probably more familiar with that, but we also have a brand new regulation, which is Section 1557. And that actually, there are some differences with respect to the compliance obligations with 1557 and Title VI. 1557, as I said, is the non-discrimination provision of the Affordable Care Act. It does apply to healthcare programs and the marketplaces. So, so as I said, there are some differences, and I think, are we?
Yeah, so apparently we're connected.
Okay.
Is that right, Christine?
Hello, yes, I can hear you.
Yes, okay, good. So I think this is a good point to pause in the DHHS presentation and then pan out and go and to DC and talk to the Department of Justice. So you can take it away, Christine.
Well, hi, thank you very much. Michael, I was enjoying listening to you. And
Thank you.
It's great to be with all of you. Oh my goodness, thank you. It's great to be with all of you. I know it's earlier there than it is here, and I hope that your conference is going really well, and I so appreciate everyone's willingness to have me on via webinar and the hard work both on our end with our tech folks and with yours to try and make it work, and I apologize that it wasn't as smooth as we would have liked this morning, but really appreciate it. And I'm sorry, Michael, to be interrupting your presentation. I was you could have done mine almost. So as many of you know, here in the Civil Rights Division at the Department of Justice, we have a federal coordination and compliance section. And I am the acting chief of that section. And I have the pleasure of working with many people who have actually worked with many people who are in the room there in Hawaii, who've worked with your offices on courts language access work, on policing work, and also on access to driver's licenses. So I'm just really pleased to be participating. And I have a lot of slides, but I am not going to go through every single one of them in great detail. Because I'm actually having some trouble with my slides. So I'm going to just go ahead and start. As Michael mentioned, the whole purpose of Title VI of the Civil Rights Act of 1964 is to end discrimination supported by federal funds. Thank you. So I just go ahead and use, what do I do here? This one. Okay. Thank you. So I just want to take us back to 1963 just to kind of emphasize this point. So the purpose of my section really is to ensure that no federal funds are used to support discrimination in any way. And also to lead by example, frankly, because we have responsibilities in the federal government, as many of you know as well. So this is a slide, and I want to make sure that everybody can see this slide. So Helena, would you just let me know if you can? This is the March on Washington. So, can you hear me?
I think we can see it, right? Yes, yes, we can see it.
Okay, great. All right, so I wanted to just circle this sign because from my perspective, this is kind of like our reason for being, right? No U.S. dough to help Jim Crow grow. That was kind of the purpose of Title VI from the very beginning. And you'll see even here in this slide with Robert Kennedy at the Justice Department, no federal funds for apartheid states. So the idea was from the very beginning, after Brown versus Board of Education, the NAACP really worked hard to make sure that the federal government wasn't supporting discriminatory activity through federal funds, and that's where Title VI comes from, and that's the statute that Michael's been talking about. And of course, President Kennedy has this great quote about simple justice requiring that public funds to which all taxpayers of all races contribute not be spent in any fashion which encourages, entrenches, subsidizes, or results in racial discrimination, and also in national origin discrimination. And as many of you know, probably all of you know, the no person part of Title VI applies to everyone in the United States, not just to citizens. And so even though that is true, we still have to fight that fight sometimes, as you know. And as Michael pointed out, Lau v. Nichols was the case, the really seminal case that basically said that the Health and Education and Welfare Office, which was HHS and the Department of Education at the time, the guidance that provided that schools must provide meaningful access for limited English proficient school kids was in fact absolutely what Title VI required. So many people ask, well, what does that mean? Like, what do you have to do? And as you all know, reasonable steps to provide meaningful access is in fact the standard. And really remember that this is about accurate, timely, effective communication at no cost to the LEP individual, and effective communication is the goal. I will say that there's been a lot of conversation about the four-factor analysis and whether and how that's to be used. And the point of the four-factor analysis, and I will just again refer you to HHS and 1557 preamble. But the point of the four-factor analysis is not to determine whether or not services are required, but how they're going to be provided and how resources will be allocated. And so, particularly where there's something of great importance, providing the services is necessary. There may be lots of different opportunities to determine how to best do that because, for instance, there may not be a certified court interpreter in a particular language, and so you may rely in some circumstances on telephonic interpretation or other kinds of language services that are appropriate to the kind of services that's needed. So I just wanted to reflect just briefly on the question of limited English proficiency, and you all know that there are lots of ways to identify who is a limited English proficient individual, and I'm not going to go into great detail there, but I just wanted to highlight that there are lots of sources for dissecting the sort of demographics more broadly of your communities and of communities across the country. And in particular, I want to highlight for you one of the technical assistance tools that the Civil Rights Division has put forth, which is this Limited English Proficiency Map app. And for those of you who've used it and played around with it, it's pretty cool. We're excited about it. And it just actually won a White House Asian American Pacific Islander award for getting at data that is specific to the Asian American community. And Pacific Islander community around sort of disaggregated data and language. So using this map app, you can get maps like the one I'm just pointing out right now, which show in really cool, easy-to-use pie charts the language breakdown, although it is based on census data, and so as you all know, census data has some limitations, particularly where you get to smaller language groups, either because of the way that they're collecting the data or because of privacy issues. And you can also get in an accessible format for people who either like the kind of raw population data or for people who need a more accessible format. These data Excel spreadsheets, which are really fabulous and helpful. So just back to enforcing Title VI and our sources of authority, just like Michael pointed out, there are lots of ways that we enforce Title VI, and we start with prevention and technical assistance, and part of why we're so excited to be participating with you. It's part of what we've been doing in a lot of instances in our great interactions in Hawaii with a lot of the offices there. And I would just point out, actually going back to this slide, that the other source for compliance requirements are the assurances that are signed by agencies when they receive the federal funds. So that way, in addition to Title VI and regulatory requirements and any other statutory or regulatory requirements, there are contractual requirements to ensure compliance with the law as well. And many of you know Executive Order 13166 back in 2000 amplified the requirement to provide meaningful access. It didn't do anything new in terms of the law other than to say that the federal government too needs to be providing language access because Title VI doesn't apply to the federal government. So it's kind of a glass houses provision, but also it inspired and required LEP guidance that has come out. As Michael pointed out, HHS has LEP guidance, DOJ does, and most of the other federal funding agencies do as well. Remembering that the goal in the first instance is always to achieve voluntary compliance, we provide agencies the opportunity to cure. There is an administrative complaint process. We also conduct compliance reviews across the federal government, and my office has not only the responsibility to ensure, it's a portion of the responsibility actually, to ensure compliance with Title VI by DOJ recipients, but importantly, we were given coordination and coordination authority and interpretation authority for Title VI broadly, and also for language access provisions through a couple of executive orders. And so part of what we do is work with all the other federal agencies to ensure consistency and effectiveness of enforcement and policy and technical assistance and outreach. And so we're pleased to do that with HHS and other agencies. We also conduct compliance reviews, as do other agencies. These are reviews that don't have to be inspired by an investigation, but could be part of an overall process of ensuring compliance. And the Department of Justice has the unique role of having litigation authority to enforce Title VI as well. And we can seek injunctive relief, such as policy changes. If it's an intentional discrimination claim, we can seek damages, as can private plaintiffs in intentional cases. And obviously there's a monitoring component, and as Michael said, rarely, but it can happen, withdrawal of federal funding. So I'm just going to keep walking through this. So in particular, I just wanted to highlight on the technical assistance front that in 2015, one of my staff attorneys, Alyssa LaRoe, came out and worked with the OLA, Rebecca, and others to provide technical assistance to law enforcement agencies and others across the state of Hawaii. And I was really pleased that she was able to do that. And language access in law enforcement is, I believe, an important and continuing struggle, something that we've seen actually in the press in some high-profile cases, one particularly out of Alabama and others as well. We actually filed a statement of interest in a case in New York. These are briefs that we help the court understand how to interpret Title VI. And in that case, a legal aid agency had brought a lawsuit against the New York Police Department for failure to provide language services for domestic violence victims, some of whom were actually arrested because their perpetrator was used to interpret. And that case is ongoing, but we filed a statement of interest in that matter. And many of you might know something about our state courts enforcement program and technical assistance efforts. And I'm not going to go into great detail on this, but you will see in the full range of the types of administrative enforcement that our office and other offices can conduct in the Title VI arena, from a letter of finding against the North Carolina court system for failure to provide interpreters in court proceedings, including in child welfare and domestic violence, and yes, even criminal cases, where on occasion prosecutors were interpreting for defendants. And that case the resolution in that case is still ongoing, but much improved, much improved. Just this week, we issued a settlement we announced a settlement in Los Angeles, one of the counties with the most LEP individuals, more than many, many states, millions of LEP individuals. And we were able to achieve voluntary compliance with them. There's all of this is on lep.gov if you're interested. There have been numerous other settlements, including in Colorado. In Hawaii, you might know that on March 24th, 2015, we actually reached a settlement, a resolution agreement after a successful technical assistance journey with the Hawaii judiciary and Melody and Justice Rushton-Wald and many others. And as I put in the press release here, that our acting assistant attorney general praised the Hawaii judiciary, and I recognize and want to congratulate the judiciary for those efforts, and as well as for the efforts that have led broadly to access to justice in the judiciary and a very high ranking on the National Center on Access to Justice Index. We had just issued a report on September 15th about our language access in the courts, and I commend that to you for your review if you are interested. I just wanted to touch a little bit longer, for just a piece more on the litigation aspect. So I mentioned that we filed a statement of interest or a friend of the court brief in the Padilla matter in New York. And many of you know we also filed a couple in Hawaii on the case involving driver's license tests. This is one way that we can get involved in litigation and engage in litigation. Private parties, of course, have to prove intentional discrimination. And one of the things that we are finding more and more is that private parties are bringing intentional discrimination cases for failure to provide language access in federal district courts. And they're seeking damages as well as injunctive relief. And those claims are surviving. And it's really important for you all to know that. DOJ may also bring impact claims as well as intent claims. And remedies typically involve litigation such as in such as in Garcia, the Maricopa County Sheriff's case, which included failure to provide language services in jails and other settings, along with the other claims in that very kind of famous Title VI and Section 14141 policing case. So I'm going to just keep going, but I just wanted to point out that, again, these intentional claims are based often on not necessarily the direct evidence of intent, but on circumstantial evidence of intent under what's often known as the Arlington Heights framework for proving intentional discrimination. So these can include things like the statements of decision makers, deviation from previous policy or routine practice, a past history of discriminatory conduct, blogs, newsletters, and social media. Importantly, these often begin with a knowledge of a disparate impact on the basis of race, color, or national origin. So that the entity that is receiving the federal funds has a policy that may or may not be neutral on its face, that it knows is having a disparate impact on the basis of national origin and is foreseeably harming others, people on the basis of national origin. And as a result, the inquiry goes on to determine whether or not there are other indicia of intent. And frequently, as I said, courts are finding that, at least in terms of allowing the case to get to a fact finder, those cases are moving forward. All right, so I'm going to keep going. This is a little bit more about the statement of interest. I just wanted to say one more thing, which is that, Title VI, we often talk about Title VI in the language access context, and certainly this is a language access conference. But it's important to note that race, color, and national origin discrimination occur in a variety of settings and manifest in a variety of ways. So recently we issued guidance, multi-agency guidance actually, on the application of Title VI in the emergencies context. I'll just show it to you right here. There's a link to it on our website. There have been a number of instances where our policing cases in the Civil Rights Division, as I noted, have included concerns about and requirements to.
Oh, Christine, can you hear me? We just lost your audio.
Provide more in the way of language services to Title VI allegations or Title VI findings. We've seen discrimination heightened against refugees and immigrants, and Title VI can address those kinds of discrimination. Certainly in the environmental justice area, in education, in child welfare and social services, and in health. Title VI is an important tool to ensure non-discrimination on all bases. And so with that, because I'm ending with health, I'm going to turn it back over to Michael.
Okay. Thank you, Christine.
Okay, well, I'm just going to interject with a few comments just to help provide a little context. So yesterday, I think most of you were here yesterday, and we heard a lot about the historical events that led to the passage of Hawaii's language access law. And if it wasn't clear then, or if you hadn't been through one of my trainings, Hawaii's language access law is Pretty similar, substantially similar to Title VI and Executive Order 13166 and the guiding regulations that have come from that. So when you're working towards compliance with Hawaii's law, you're also complying with federal law, most likely in the Title VI manner. And so Christine did an excellent job of, showing the breadth of Title VI. Pretty much you get federal money, you gotta comply with Title VI. Hawaii state law is you get state money, you got to comply with state law, but it's pretty much the same thing. And then also that DOJ, because it's so broad, you have to look at what the DOJ guidance says, but as Michael was explaining, with DHHS, Department of Health and Human Services, they're looking at the agencies that receive funding from that federal agency, DHHS. So Affordable Care Act is within his purview, so you may have differing obligations under Affordable Care Act, but you also got Title VI to worry about. And then if you're getting state money, you got to worry about state law as well. And then Christine had also mentioned that their involvement in investigating state agencies, for example, their attorneys were right over on Punchbowl Federal Court filing statement of interest against our state departments for an intentional discrimination claim. So they're here, they're doing it. So you got to be a little bit afraid, but not today. Okay, so with that, I'll turn it over to a discussion of the Affordable Care Act, and Danielle.
Aloha, everybody. So I'm Danielle, or Danny Archuleta, and I'm with HHS's OCR office. I'm actually based in Seattle. So Michael mentioned our region is fairly large on the West Coast. We have a San Francisco office, an LA office, and a Seattle office. So I'm excited to share with you, can we get the PowerPoint back up? The PowerPoint, okay. So I'm excited to share with you about Section 1557, which is from the Affordable Care Act that you've been hearing about. And so I'm going to talk about the background, the scope, the language access requirements, including some new procedural requirements, some new definitions, and some case examples. So I think what's important is to just build a little bit of a foundation here is that Section 1557 and the language access provisions in it build on Title VI. So there are some new ways that we're looking at things, but again, it's sort of an evolution of the law. It has some more consumer protections in there, and so I'm excited about it. So to go to the background, so Section 1557, in addition to prohibiting discrimination on the basis of national origin, it also covers race, color, sex, age, and disability in certain health programs and activities. So we're, again, only going to focus on the language access portions here, but if you have questions about the rest of the provisions, feel free to contact us or see us at the consultation, which is going to happen immediately after this session. The provision in the Healthcare Act went into effect in March of 2010, and then just recently this year in May, HHS OCR published the implementing regulation under Section 1557. So we've been enforcing under the statute for about 5 or 6 years, but now we're going to start enforcing under the specific provisions of the regulation. The effective date of most of the provisions in the regulation was July 18th of 2016. So again, this is really new, and just if you have questions about the effective dates, let us know. So the final rule under Section 1557 applies to health programs and activities, any part of which receives federal financial assistance from HHS. So that's probably the provision that most of you, if you're covered, will fall under. We also regulate ourselves, so any health programs and activities that are administered by HHS, and any health programs and activities administered by Title I entities, and those include the state-based marketplaces. And note, though, that principally engaged in health services or health coverage means that all of the entity's operations are considered part of the health program or activity. Okay, so we have a few enforcement mechanisms. These are fairly similar to the enforcement mechanisms we already have. We'll enforce Section 1557 through the complaint process. We'll also do some compliance reviews, and we'll provide guidance and technical assistance. What's important to note is there is an explicit provision now that there's a private right of action, and that does include compensatory damages. Okay, so some of the newer requirements, and again, these kind of build on what's already existing for most covered entities, is a procedural requirement to have a coordinator and a grievance procedure. This applies to covered entities who have 15 or more employees, although we encourage all covered entities to adopt these, is to designate an employee to serve as the entity's compliance coordinator who investigates grievances, and requires the covered entity to adopt a grievance procedure that incorporates due process standards so that they can handle complaints about language access or other provisions internally. The grievance procedure and designated employees' responsibilities must cover all the basis of discrimination. All right, and then the second procedural requirement is to provide notice of non-discrimination to the public. So covered entities must post a notice advising individuals of their rights and of the covered entity's non-discrimination obligations. And that must be in a conspicuous location. It must be on their website. It must be on significant communications with the individuals. And if there are small-sized communications, they can have a smaller statement rather than a larger statement. We have provided samples in the regulation and also in your packets. And the effective date requiring these notices are not set until October 17th, 2016. So if you don't have these done yet, you're still okay for another month or so. But we want to let you know about it so that you're ready.
Chop, chop.
Let's see, there's also requires taglines that notify individuals of the availability of language assistance services in at least the top 15 languages spoken by individuals with LEP in the relevant state or states. And then if it's a small size publication, then you have to include at least 2 of the languages, the top languages. So OCR has helped offset the cost of some of the translation of these taglines and documents by translating the non-discrimination notice, the statement, and the taglines into the languages triggered by the state threshold. All right, next slide. Okay, so I want to go over what's required in the non-discrimination notice. So there are 7 elements required. And again, if you already have notices, you may already have most of these elements. But just to highlight all of them in case you need to do some revisions. So the covered entity does not discriminate on the basis of race, color, national origin, sex, age, or disability in its health programs and activities. 2, that the covered entity provides appropriate auxiliary aids and services. 3, that the covered entity provides language assistance services. 4, how to obtain auxiliary aids and services and language assistance services. 5, if applicable, the name and contact information for compliance coordinator. 6, if applicable, the availability of the grievance procedure and how to file a grievance, and also how to file a discrimination complaint with us at OCR. So as I mentioned, we do have samples of the non-discrimination notice, the shorter statement, all in the regulation, and the taglines, all in the regulation and also in your packets. So I'm going to skip over those slides. All right, so as a resource, OCR made available a table displaying lists of the top 15 languages spoken by individuals with LEP in each state, in the District of Columbia, in Puerto Rico, and each U.S. territory. So these languages are compiled using the most recent state-based data set available during the development of the rule, and they come from the 2014 American Community Survey from the U.S. Census. And so if you have any questions about this, let us know, or you can see us at the consultation and we can go into more detail. But again, this was just information we compiled using the census data. All right, so the general rule under 1557 is very similar to Title VI. It's requiring covered entities to take reasonable steps to provide meaningful access to each individual with LEP eligible to be served or likely to be encountered in its health programs or activities. And when OCR starts looking at these issues, we're going to look at different factors in evaluating compliance. But what we're going to do is give substantial weight to the nature and importance of the health program or activity and the particular communication at issue to the individual with LEP. And then we'll also take into account other factors, but that one is the most substantial. And so some of the other factors could be whether the covered entity has developed and implemented an effective written language access plan appropriate to its circumstances. So some additional requirements for language access services. The rule, again, just kind of builds on what was already existing, that services must be free of charge to the individual, accurate and timely, provide privacy and independence of the individual, and that language assistance services must include oral interpretation from a qualified interpreter, written translation from a qualified translator, and taglines. And then the regulation codifies some previous guidance from OCR under Title VI regarding the use of family members or friends for interpreters. So it does state that the covered entity is not permitted to rely on an adult family or friend to interpret, except if there's an imminent threat to the individual or to the public, or if there's a specific request from the individual followed by acceptance by the family or friend to be the interpreter and it's appropriate under the circumstances. And then again, we codify that the covered entity may only rely on a minor family member or friend when there's an imminent threat to the individual or the public. And then to go a little bit further, I know that there was a lot of talk yesterday about staff members who are interpreters, that the covered entity may not rely on staff members other than qualified bilingual, multilingual staff to communicate directly with individuals who are LEP. And we do define what qualified and bilingual, multilingual staff means. And I'll get into those in a second. So in the interest of time, I'm not going to get too much into video remote interpretation requirements, but just know there are specific requirements in the regulation that are new about clarity and quality and training. Okay. So I think what's at the heart of some of the new provisions are the new definitions. These three are pretty normal. The individual with limited English proficiency and what it means, and then taglines that are short statements written in non-English languages. But I think the newer ones are coming up. Okay, so qualified bilingual, multilingual staff. And this means a member of the covered entity's workforce who is designated by the covered entity to provide oral language assistance as part of the individual's current assigned job responsibilities, and who has demonstrated to the covered entity that he or she, one, is proficient in speaking and understanding both spoken English and at least one other spoken language, including any necessary specialized vocabulary, terminology, and phraseology, and two, is able to effectively, accurately, and impartially communicate directly with individuals with LEP in their primary language. And then the LEP definitions continued include what a qualified interpreter is for an individual with limited English proficiency and a qualified translator. So you can read those on the slides that we've provided, and we can go into more detail if you want. But note that we don't require any specific certification, although the certification in a lot of instances may be evidence of the interpreter's qualifications. All right, and so then I'm just going to get into a couple of enforcement case examples and some initiatives that OCR has been working in the language access area. So first, we had a couple of initiatives that were based on opening compliance reviews against hospitals around the country. These focused on, in part, the language access services that the hospitals had in place and how they were providing them. One was under a national HIV/AIDS initiative, so it also looked at other provisions. And then the second was advancing effective communication in critical access hospitals. And the critical access hospitals get special funding from HHS in order to operate in rural areas. They are, usually 25-bed facilities, and they're rural or isolated from other facilities. So they're pretty important in the emergency context when individuals in remote locations of the country need to access hospitals. And out of that initiative, we actually have the first case example that I want to mention, and it was a resolution agreement between OCR and Shenandoah Memorial Hospital, which was a hospital in rural Virginia. We did have a resolution agreement for them to improve their language access services for individuals with LEP, including addressing LEP patients plus their companions who may be LEP. Then we also had a case out of California against Me Memorial Hospital, and this addressed languages of lesser diffusion. So they were encountering in this one area individuals from Mexico who didn't speak Spanish. They were speakers of this one dialect called Triqui Bajo, and they were having a hard time finding interpreters, and they weren't providing them when needed. So the resolution agreement helped address that issue. And then last, we've also engaged in resolution agreements with various state human service agencies, including the Hawaii Department of Human Services. And that's a little bit closer to home, but we can talk more about it if you want to add anything.
I think it was mentioned yesterday, so we did have an agreement that required monitoring with DHS. So we can talk more about that if anybody has questions.
Okay, next slide. All right, so I think that about wraps it up. But do visit our website. We have a lot of Section 1557 as well as other information on there. There's also a listserv where you can sign up and get information when there's updated guidance or when there are case resolutions. And it's hhs.gov/OCR. And then next slide. Yeah. And then if you have any questions, you can feel free to contact us. As Michael mentioned, we're doing a consultation right after this. We also have business cards, or here's our general information too. And note that there's a dedicated email specific to Section 1557, and you can email that inbox directly if you have questions. Okay, thanks everybody.
Okay, thank you, Danielle. Your presentation had triggered a number of thoughts for me. Do you guys remember the LEP panel yesterday and those horror stories of their experience seeking, emergency health care? Watching this and seeing all these guidelines, you could see all the places where this kind of broke down in their experience. And so I think what the Affordable Care Act and all these provisions, it is much more prescriptive than what the Title VI regulations will have you follow. But I would say that it really harmonizes with Title VI. So, some of you may come from an agency that thinks, okay, well, I'm not a covered entity under the Affordable Care Act, or we don't get funding from the Department of Health or Human Services. But I would encourage you to look at these guidelines because they're so prescriptive. They give you some definitions of what a qualified interpreter or translator are. What are some of these things that they consider above board, and you can take those ideas back to your planners and say, okay, maybe we need to look at setting up some kind of standards for our interpreters. This is what the Affordable Care Act says, and you could document this. So in the event of an investigation, you could say, hey, we're working on it. We've had these meetings. We put it in our plan. We borrowed some language from ACA, whatnot. This can demonstrate best efforts at compliance, I would say. So I take to heart this harmonization and don't say, hey, it doesn't apply to us, because it kind of does. The other thing that I was thinking too, the four-factor analysis, for those who are familiar with it, the guidances on Title VI coming from the Department of Justice that accompany the Executive Order 13166, it mentions 4 factors to take into consideration when you're working on your language access. The third factor is the nature and importance of the service you provide. Among other factors, resources, frequency, and the different LEP groups that you encounter. But what the Affordable Care Act has done here is they said, okay, the nature and importance of the service, we're going to hold a premium, and also state law uses these 4 factors. We put it in our we codified it in our law. So I would say look at that factor first, and that will help guide you on determining how else you're going to provide these services. So I like that, that you brought that to the front. And then with that, we're going to go to DC and take a look at what the District of Columbia has done with its own municipal laws for language access. Okay. Stephanie, thanks.
Am I on here? You can hear me, right? Oh, yes, I can hear myself. I know you guys missed me overnight. I'm back. So DC does not equal federal government, although these are lovely people, and I've gotten to talk to them earlier today. But I think kind of what I want to focus on, since a lot of what has been set up here is more around kind of enforcement, is talking about kind of incentivizing compliance, but kind of without the hammer. I think in DC, working at the Office of Human Rights, we've noticed over time that, sometimes always threatening, the person who, or the agency that may be violating the law is not always the best way to get them to come around. And just like I was saying yesterday with, community people, putting people first really is at the center of getting this type of work done, even if it's supporting, employees at these agencies to get the job done and giving them the incentive to do the right thing in those moments. So I just wanted to share, and I know we also are kind of short on time, some of the things that we've tried to do outside of just enforcement to kind of get people to comply with language access. And it really comes down with providing kind of baseline resources. So, we've talked a lot about, making sure websites are kind of up to date, creating taglines, or having general information that are available in a number of languages, and even access to telephonic interpretation and other types of translation services. But one of the main things that we've done, because the entire district government is covered by the Language Access Act in DC, and that not only includes the government agencies themselves, but also any of the other entities that they work with and provide grants to, or provide any type of money to administer services on behalf of the government. Making sure that in those contracts or agreements that they have with those other entities, that you're including language around language access. So saying, if you are a health clinic that has some sort of grant under the Department of Health, that, you are going to be encountering people that may or may not speak English, and these are the things that you need to have in place. Here's, the number to call for telephonic interpretation. Here are the interpreters that we can use. All of that. So it's really, really important, and that's something that we've worked with the DC Office of Contracting and Procurement to make sure that across the board that all contracts with any entity between the government and that entity includes that language, especially if there are direct services to people. So that's one thing that I would say is a good avenue to go down. Another thing that we've done is issue different types of guidances around protocols when doing walkthroughs. So there are a lot of businesses that are starting to kind of come up in DC, whether it's opening, a corner store, or, starting a development project, making sure that there are protocols for, the business community. So we have a Department of Consumer and Regulatory Affairs that does inspections, that issues business license. We have another entity that issues licensing around like alcohol and things of that nature, making sure that when you're going to do like on-site visits of these places, that you know that you have a phone, to use to call an interpreter, that you know that you have, a language line card to show someone to point out their language, doing research ahead of time to ensure that you know what, language that business owner speaks. Because a lot of times maybe, the owner may not speak English, but maybe, someone else that works within that business or is helping with that project speaks a little bit of English, but may not be there the day of that visit. So making sure that you have that information up front, and also, planning ahead on those walkthroughs. We had a little bit of an embarrassing incident a few years ago, unfortunately, with the mayor, who was going around doing site visits of corner stores that were selling kind of illegal marijuana. It was some sort of, I can't remember what it was. I forget the name of the inspections or what they called them. But unfortunately, the mayor walked in, and the person that was working behind the counter was LEP. And the mayor was trying to be a little bit stern and forceful and say, you can't be selling these types of products, or you can't be selling this type of stuff here. And the guy really did not understand. And the mayor thought that he was just being funny about it and was like, no, I'm serious. And the guy just looked deathly afraid. This is all on camera, by the way. You guys could probably Google this. But just in that event, it's like, okay, if someone were to notice that there, was an issue here, or knew ahead of time that, this business is owned by someone who's Ethiopian and may speak Amharic, and perhaps there are staff that you may encounter here that speak Amharic, would it behoove us to have an interpreter with us to make sure that this goes smoothly, especially if there are cameras there? So those are things that I would just say, are things that we have to think ahead about, but also that can help when it comes down to compliance, right? Because yes, we could have followed up and said, do you want to file a complaint against the mayor for harassing you, when you didn't speak English? But that's not always the best way to go about it. So making sure that we have those resources and that information ahead of time, or even that we have plan Bs when, we kind of walk into situations like that. And the last thing that I wanted to bring up, and one of, I think, the best features of the language access law in DC, is that built into the law, we have 3 consultative partners that kind of aid us with kind of compliance monitoring. There are 3 offices under the mayor that focus on African affairs, Asian Pacific Islander affairs, and Latino affairs. That all kind of work with our office to ensure that the communities are getting quality service, but also that the agencies have the support that they need and the information that they need about those particular communities. The other arm to that is a coalition that actually put forth the law in front of council back in the early 2000s, which is called the DC Language Access Coalition, that now goes by a name, I think, Many Languages, One Voice. And they are a number of community partners that have come together from, all different backgrounds, all different ethnicities, to ensure that services are, directed, and money and resources are directed towards the communities that need that help the most. So all 4 of those partners work with our office to review plans that agencies put together. So, and I'm happy to talk more about the granular details of the Language Access Act in DC and kind of how our program is set up. Because, not only is, all of the agencies covered, but they also have to produce plans every 2 years, and they have to report quarterly on those 2-year plans to our office. And I have a lovely annual report that I created last year that has scorecards for each of those agencies, so they, we're tracking their progress, and that's more of the hammer arm of kind of, enforcing and making sure people are complying, but having those other entities kind of having eyes in and also providing feedback and support to the agencies is really critical to kind of getting them to move forward. So if you're not doing that here in Hawaii or in other jurisdictions, I would definitely say, just because you don't have it down on paper as far as working with community partners, it's very important to have those voices to be part of the conversation, and for them to have that direct access with government agencies, because really they're the people that are the intermediaries between the services that we're trying to provide and the actual outcome being successful on the other end. because, when we can't convince someone to come and file a complaint, whatever went wrong in those instances kind of gets lost. So you want to make sure that we have that accountability there and that we're forever supporting the people that are actually doing that work. So if you don't take anything else away from me, from being here, putting people first, offering support, and really using all of your resources and all the people that kind of touch this issue together to get the outcome that you want. Making sure that you are engaging with maybe unlikely partners in order to get the information that you need to best serve the communities, and not thinking that we have all the answers because we've tried and tested all of these things out and none of them have worked, or only a few of them have worked, and we have to pivot and move here. Really listening to people and getting all of the advice from all of the people that touch this issue is the best way to go about that. So hopefully that was helpful.
That was very helpful. Thank you, Stephanie. On behalf of the Office of Language Access, I'm really glad you're here, and I think there's so much that we can learn about our efforts from your experience. And I know that there's various differences in our funding and our staffing, and also the extent to which you're able to work with certain agencies in the DC area. But I also want to represent Hawaii here to you guys and say we're really good at working together too. You just look around the room and there's like maybe 2 degrees of separation between folks, and I have a sense here that all of us have the shared goal of achieving meaningful access for our LEP members of our community. So even though you guys have a bigger stick,
not so much.
Don't forget that they also have carrots too, and they're here to help. And I'm just going to assume that none of us here are like English only and we don't care. I'm just doing this because I'm required to. I think that most of us really just want to do it because it's the right thing and honor the spirit of law. And I'm thankful for Christine for all the images that she had put on her PowerPoint, which just shows the underlying policy and the sentiment that as a matter of example, the federal government is not going to encourage or somehow say it's okay for any of our tax dollars to promote discrimination based on national origin. And so let's all keep that in mind. I have a couple questions. So if it's okay, we'll just encroach on our break period for 5 minutes, but still come back. So instead of a 15-minute break, make it a 10-minute break, if that's okay. Oh my goodness. Lots of questions. Okay, well, I'll have to look through these, but we'll have some time later. But there's 2 questions here, specifically about this qualified term, qualified definition. Could someone be considered a qualified bilingual staff member if language ability was only a, quote, preferred, end quote, job qualification, but the employee's normal job duties included communicating the same info in English? Do you have any thoughts on that?
Can you repeat the question?
Okay. Could someone be considered a qualified bilingual staff member if language ability was only a preferred job qualification, but the employee's normal job duties included communicating the same info in English?
That sounds pretty specific. I mean, I think it would need to meet the definition that's in the regulation. And if it varies from that definition, then it wouldn't meet it. So if it's more of a fact-based question, we would look at it probably on a fact-by-fact basis and then, make a decision.
Yeah, I think it really, it would depend on the circumstances, but for our purposes, if you were, you would have to meet the definition of a qualified interpreter, basically, or a qualified bilingual or multilingual staff. to sort of be in compliance with the regulation, the 1557 regulation. So that would be the difference.
Yeah. So sort of in that same vein, I have another question. Does one law or guidance supersede another, for example, federal over state? And so just the tenor of both of these questions, like I can feel whoever wrote them, they're like, I just want to know if I do X, am I okay? And I guess I would just say to that person, it depends, I mean, that's why you have lawyers to like do the analysis. It's not an easy answer necessarily, and there are competing statute, competing policies, not necessarily competing in the outcome, but you have to look at it and determine like which is controlling here, which has jurisdiction, and you got to look at the facts. Yeah.
Yeah, and just to add to what Becky said, I know that the Hawaii state law is very similar to the federal law that we have. So I think basically if you're complying with the federal requirement, you're basically complying with the state requirement. Although I know that the state law does have some requirements that we don't, that are different, so that are additional. But one key thing for us, if you are, although a language plan is not necessarily, we don't require it, it really, if you've been thoughtful about having a plan in place, having policies and procedures, I think it was mentioned yesterday's session many times, training is a key component. You may have policies and procedures that codify your language plan, but if your staff doesn't know about it, it really has to be spread out. I think the other thing too is making sure that your leadership within your organization understands why this is important. So I think it was Elena who mentioned, she did a PowerPoint for her leadership in her agency. So I think, making sure that you have the commitment from the highest level and understand so that they understand why this is important. It's not just that it's a federal requirement or a state requirement. It's also you're serving your community. Why is this important? You want to be able to reach out to everyone who's eligible to your services. So those are all really key components in terms of, and certainly when we get a complaint, somebody said document, that is very critical because, we do see a wide array of, language assistance plans. And certainly the better documented you are, if we can see, okay, look, here is how we get an interpreter. Here are the resources that we have for this. Here are policies and procedures when we interview staff, if they know how to get a language line or an interpreter or a qualified interpreter. I mean, that makes a difference. So, yeah.
Okay. Oh, and I just wanted to add. Oh, sorry, Christine.
Is that okay? I'm sorry. I would just want to add, as to the question of the differences between which law applies. I mean, the floor is the federal law. And so certainly a state law can require more in the way of compliance, but it can't require, if it requires less, the federal law would still govern as to that. So you can't go below the floor. And I would just also say that the Attorney General of the United States, after our office worked hand in hand with the Office for Civil Rights and OGC over at HHS on these 1557 regs, the Attorney General, she actually signed off on the regs and the preamble as consistent with Title VI. And so it's really, it was always very important, and I just want to underscore what I think Rebecca has said. It's always been very important that the 1557 regulations around language access be consistent with interpretations around Title VI. And so that we worked very closely with that in mind, and hopefully that's apparent.
Yeah, and also I just wanted to add, it's important for each agency just to know where it stands relative to the funding sources. So the one question asked, like, well, so does federal always trump state? And gosh, if it were that simple, you wouldn't need lawyers, right? And just think about how many agencies out there might get a state funding or it's a state grant, but they don't get any federal funding. So it wouldn't, it wouldn't be a situation where federal law trumps state. It's only state law applies to that agency as a matter of Title VI. Even though if you're following Title VI, you're also most likely complying with state law. And so there are some differences. It's maybe too simplistic to say the federal always trumps state. You really got to look at the facts. But I really do think that all of these laws on language access do harmonize. And so if you're proceeding with, in the spirit of providing meaningful language access, and you follow a lot of the guidelines that are put out by the various agencies, including the state, including even DC, if you're gonna look over there at DC, you're on the right track. So I got a lot of questions here, but it's 10:07, so I'm gonna sort through these, and these guys are on hand, and then hopefully we'll